We'll hear argument now in Case 23-753, the City and County of San Francisco versus the Environmental Protection Agency. Ms. Steele?
Mr. Chief Justice, and may it please the Court, Section 301B1C of the Clean Water Act assigns EPA the job of setting the effluent limitations necessary to meet and implement water quality standards. The water quality standards are not the limitations themselves. Instead, they set the goals for the water body. EPA must translate those goals into discharge limitations. The generic prohibitions fail this task. As Judge Collins explained below, the generic prohibitions erase the distinction between water quality standards and discharge limitations, making them one and the same. The generic prohibitions revive the very cause or contribute standard Congress repealed, and they do not function as discharge limitations. As the Second Circuit recognized, they add nothing that tells a permit holder how to control its discharges. EPA claims it uses the generic prohibitions as a backstop, an insurance policy against changing circumstances. But the Clean Water Act already gives EPA all the tools it needs to address uncertainty. EPA can reopen, modify, or terminate a permit when conditions change, and it can exercise its statutory authority to protect public welfare in emergencies. What EPA cannot do is expose permit holders to liability based on receiving water conditions it cannot control. The generic prohibitions are also inconsistent with the Act's permit shield. The shield protects permit holders from liability as long as they comply with their permit terms. But by imposing indeterminate requirements, the generic prohibitions prevent permit holders from relying on the shield's protections. San Francisco is therefore exposed to crushing criminal and civil penalties, even when it otherwise complies with its 300-page permit. I welcome the Court's questions.
In your permit, Phase 1, doesn't that contain a narrative limitation?
So San Francisco's permit is a Phase 2 permit, so we're not subject to the CSO policy for Phase 1. But Phase 1 describes a narrative condition. The generic prohibition, our concern about the generic prohibitions is not that they are narrative. It's perfectly fine for EPA to use conditions that are narrative water quality-based effluent limitations. And that's exactly what the CSO control policy requires. In EPA's own guidance, it describes what's required under Phase 1, and it describes that as a narrative water quality-based effluent limitation.
So with this permit, what is at bottom the problem?
What at bottom is the problem is that permit holders don't know what they need to do to comply. We know how to comply with the 300 pages of our permit, which tells us our discharge limitations that we need to achieve. The problem with the generic prohibitions is that they don't tell us what in addition that we need to do, and if I could provide an example of that. One of California's water quality standards is no objectionable algae blooms should form in the water body. San Francisco doesn't know how it must control its discharges to prevent that condition from forming in the water body. And we can't know because whether a condition will form in the water body will necessarily depend on what other permit holders or other non-point sources are adding to the water body and the flow of the water itself. What San Francisco can control is our own discharges. We cannot control the receiving water conditions.